and we're pursuing that. So this was filed yesterday afternoon. Stipulation, oh, there it is. There it is. It exists for temporary orders on plaintiff's verified motion for temporary orders. It sounds like doublespeak, but remember, Justin Alien came along and said, I want the child. He's also asked for the equity in the home. That is not part of this deal.
He wanted the equity in the home, $200,000 for child support
for 18 years.
Yes. 18 years. Okay.
Yeah. And that hasn't been decided yet. But now, once we get to the venue discussion, let me spoiler alert. It's going to stay in Essex County. We'll get into how that all evolved. But this is far more, to be honest, far more interesting. So here we have comes now the parties, and we have Justin Alien and we have Kelsey Fitzsimmons, and they stipulate, meaning they have come to an agreement on each of these things that we're going to talk about. Custody and parenting time. The father shall have legal and physical custody of the party's minor child, 8 months old now. The parties acknowledge that on or about June 30, father sought and obtained his 209A abuse prevention order against the mother in the Essex Probate and Family Court. That was the original document. Pursuant to the active 209A order, the father was granted custody of the minor child, and the mother was ordered not to contact the father or the minor child. The matter is scheduled for a two-party evidentiary hearing December 2nd. Mark that on your calendar. That's going to be fascinating. It's an evidentiary hearing, so who knows? Who knows what's going to happen? And remember, in that probate and family court we were in, not a traditional courtroom per se. There's not really a witness stand. The parties generally stand at counsel table and raise their right hands, as they did that day, and swear to tell the truth, the whole truth, and nothing but the truth. So we'll be there. I think it's safe to say. The parties further acknowledge that the mother is currently being held without bail in the Western Massachusetts Regional Women's Correctional Center, pending a criminal trial on a charge for assault with a dangerous weapon in the Essex Superior Court. In that matter, mother was ordered to remain away from the minor child. This is all part of that original order that Justin got, Mr. Alien got. And then this kind of stings. Yeah, they have this at the bottom, just kind of a standalone reference. As such, mother shall have no parenting time. That's pretty bold slap in the face, and it's unfortunate because it's not like it doesn't happen. It's not like you can't make those arrangements with somebody that's incarcerated. Right. You can, but they're not. Okay, and this is by agreement. Okay, child support. Here we go. Commencing October 23rd, that was the day of the hearing. Mother shall pay child support to the father in the amount of $12 per week, pursuant to the payment method described in paragraph 3 below. The parties acknowledge the child support payment of $12 per week is the minimum child support order pursuant to guidelines. And those guidelines, every place has them, right? It'll take into account assets, income, obligations, bing, 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 who has money. What does that tell you? That she's having to pay anything. What's your take on that?
The court's going to order it no matter what. She probably has $12 a week coming to her for her work in jail. That's probably what it comes down to.
I mean, the guidelines.
Ridiculous things.
Yeah, I can't even imagine guidelines using that it's a nothing number. It's nothing. It's $48 a month.
$48 a month. So you're talking about what? How much per year? $800, $824, $24. You're talking about under $10,000. Yeah, you're talking about under $10,000 through 18 years. Is that what we're talking about?
That's an interesting calculation that may come into the mix. Yeah,
considering he's asking for $200,000, probably from the house. He wanted $200,000 from the house.
That's
an hour.
Yeah, that's roughly the equity, and he just said, "I want it all." The parties agree. This is under the payment method. The parties agree and acknowledge that the mother holds title to the real property located at the Phillips Brooks Road location. The parties also agree and acknowledge that on August 22, 2025, the mother listed the North Andover property for sale, and that the mother has accepted a contingent offer to purchase the North Andover property. I don't know how I feel if I'm the buyer in this whole mess, because I'm sure when they got involved, it was like, I'm just buying this house. It's a modest, lovely little home, but all of a sudden you're knee deep in this mess. From the mother's
maybe the buyer wants to hold tours of it.
Jeez.
I'm just
I
kidding. I
hope
hope
not.
not. I
I
hope
hope
not.
not.
And I say that facetiously,
Yeah, I
but
know.
we've seen places where it's happened.
Yeah, and maybe they'll put the door back on that room upstairs where they say she came out from behind the door. You remember
Right,
that?
right. And there's no
There's
door.
no freaking door. How'd she come from behind the door? It's magic. Anyway, from the
Maybe
mother's
they took
net.
the door. Maybe they took the door as evidence. Okay.
Well, having put a few doors in and taken them out, you have to have the right door jamb and the right. There's no door. There's no, unless they came in afterwards as carpenters and patched it up. There hasn't been a door there for a while, and you can tell it's stylishly designed to be that way. Anyway, what was I looking? Oh, from the mother's net proceeds from the sale of the North Andover property, $50,000 shall be held by the father's counsel in the IOLTA account.
IOLTA account. So that's a lot. That's a far cry from the $200,000
yeah.
of equity that you have. So there's agreement. So what an IOLTA account is that almost every state has them. Lawyers have to have them because when you're putting other people's money in that, it's kind of like it's an insured account, really, of some sort. I'm not using lawyers' terms here. But it's a secure account, and if you are a lawyer and you tend to spend that money for something that you're not supposed to spend it for, you in big trouble.
Yeah,
all right, and it gets interest. IOLTA accounts get interest.
That's true, and the TA stands for trust account. So that's
right.
The concept there. And as we know as attorneys, you have a trust account. If you touch that, red alert, red alert. I think I've mentioned before I had that problem where the bank screwed up and said that I had moved funds that I hadn't moved, and the bar is on you like, bam, white on rice. And you have to then go through, all of a sudden you're guilty until proven innocent, and you have to go through the documentation and the bank says, yeah, sorry, oopsie, yeah, thanks.
Yeah.
No longer working with that bank, the initials of which are Wells Fargo. Okay, so following the closing on the property, that 50 grand goes in there from the net proceeds from the sale. Father's counsel shall disperse. So again, Justin Alien does not have access directly to the money. It's in this trust account from which father's counsel shall disperse $12 per week to the father from the escrow account. Escrow? Did anybody mention escrow on the courthouse steps?
You did. You said right at the beginning this is going to go into an escrow account,
and they wouldn't even acknowledge that. Come on,
they wouldn't acknowledge that. We know it had to go into an escrow account, and quite frankly, this is actually a smart move. I know you're going to hate me for this on behalf of the father because I think it puts him looking like he's in a better position than when he's grabbing the whole equity, which is what he had asked for. Okay, so now there's been a negotiation. Probably the lawyer said you can't get that, and you know what kind of a dumb.
Well, he did file it pro se. We know that. So
but that means that's what he wanted. Yeah, but that means what he.
Sure.
That's what he wanted. Okay.
And now we know they've negotiated this number, and he comes out looking less like sniveling money grubber, slightly less. So he gets his 12 per week, and the father's counsel shall provide an accounting of the escrowed funds. This is going to be the simplest accounting ever. So moving on, health insurance for the minor child. Now, he's a firefighter. He's probably got a great insurance, right? Mm-hmm. The father shall maintain his employer-sponsored medical insurance for the minor child if, as and when the minor child ceases to be covered under her health insurance. So she's still under the cops. She's at administrative leave now. Remember, she was on it, off it, on it again. So she's got great coverage too. I guess if you looked at the numbers, maybe it was more economical to have the child on hers because she's the natural mother.
Also, yeah, well, maybe that was the case initially. Yeah, and the child was, that's possible. And they were not married yet. Yeah. So that would be probably more likely that would have happened.
Yeah. So they both have government jobs with great health care, and so the baby is covered on that. Uninsured medical, dental, and vision expenses, because even good insurance ain't the best. You're paying something. The parties shall share equally in any and all uninsured medical, dental, therapeutic, and/or orthodontic expenses for the minor child, with father covering the first $250 per year. What does that get you? What does that get you? Doesn't get you much. On a monthly basis, the father shall submit to father's counsel in writing proof of payment for any and all uninsured expenses, including but not limited to blah, blah, blah. And then so the attorneys are going to share this information to make sure that he's doing the right thing, that Justin Alien is paying his chunk. He's on the hook for the first $250. Yeah, again, those numbers are just a joke. Right? Nothing. That's for the year. 250.
Yeah.
Yeah, right. Child care, daycare. The party shall share equally in all child care or daycare expenses on a monthly basis. Father shall submit to his attorney proof of payment of any expenses. We know that his parents are watching the child at this point. Counsel
Well,
shall then.
that always leads to an interesting issue, because I've seen cases where then the in-law, relative, family member, parent bills for the child
Yeah.
care, right? So, I mean, I don't know if they discussed that's not going to happen, or whether that's going to be something that we'll see later down the road. This is like a divorce agreement here.
It is.
And
That's why I'm getting
totally
queasy.
right. I know.
Because that's why I'm not doing family law. Yeah, and this is the worst part, when you're wrestling over a child. It's the worst, and in this case, it's extreme when somebody gets shot while wrestling over a child. This is interesting. Communications between the parties, as noted above, pursuant to 209A, the order that Justin received, the mother is prohibited from contacting the father and the minor child. That said, the parties agree that father will share updates, no thanks, about the minor child, such as his diet, general well-being, development, medical dental appointments, new activities, discoveries, evolving likes and dislikes, milestones. This is just so sad. First steps, first words, as well as photographs and or videos of the minor child to the father's counsel on the 15th and 30th of every month. Father's counsel shall share the same with mother's counsel within 24 hours of receipt of same. Now, let's talk about this timing. If you read this, and a lot of this is boilerplate, and they fill in the details, but this sounds like, man, he's got this baby forever. That's what it sounds like.
That's what it sounds like. Sounds like because remember, he's got total physical control. I mean, it's not joint control, and it's not even joint. It's not even, how some agreements he'll have the physical custody, but there'll be shared control of everything else. That's not that here.
No. And, let's assume, and we are still waiting for the Supreme Judicial Court entire panel to rule on the latest emergency efforts to get Kelsey Fitzsimmons out of jail. Let's assume that fails. Okay. She's done a month already, a little more than a month. I think it's 5 weeks. At the time we were at the hearing last week, it was 5 weeks. So that means you got another 4.5 months, give or take, under the provisions that the court imposed. And the theory is that it'll go to trial before that. That's the theory. If that's true, and if she's acquitted, or if she's convicted and then sentenced to probation, or she could be out by the springtime. And so all of these things, it's called a temporary order. All of these things would then have to be renegotiated, and major changes would be made, you would think.
Oh boy, yeah, but the things that you missed the first year of being the mother to a child, wow,
heartbreaking every day.
Right.
I can't
every day
even
is heartbreaking, right?
Yeah, minor child's. I love this too. This is this was not just a random thought. This is, if they didn't think about we're going to baptize the child, this would never have come up.
Right.
If and or when the minor child is baptized, the father shall ensure that the ceremony is video recorded. The father shall send father's counsel the video of the baptism that same day, and the father's counsel shall forward the same to mother's counsel. The parties agree that the mother's sister, Madison, may attend. Well, that's big of them. May attend the baptism.
And then there's nothing, I've seen online, because there was some suggestion about this, about who would be the god parent to this child, right? In a baptism. There's nothing here about that, okay?
And if Madison is the only person that can go from Kelsey's side of the family, does she have any role in it other than just she gets to be there?
Yeah, can you imagine just being there? Can you imagine that?
Yeah, I mean, that's not a video that I'm dying to see.
I mean, but just how she feels about being there, it's like it's walking into the enemy camp. Oh.
Well, it'll be documented for better or worse. The parties shall submit the stipulation to the court for approval and adoption into a temporary order, et cetera, et cetera. Both parties reserve their respective rights, interests, claims, and defenses in the matter. All provisions of the stipulation are entered into by the parties without prejudice and may be reviewed by the court upon appropriate motion by either party. So in most cases in family court, change circumstances is the magic phrase, and it happens all the time. So getting out of jail, probably a changed circumstance.
Yeah. Yeah.
So that's there it is. Just an alien. I'm still going with alien.
I know you are. And then the other thing, even with the baptism, when I'm thinking about, it doesn't say that Madison can hold the baby, can kiss the baby, can touch the baby. It doesn't say anything. Just be there. And then I could see, given the fact that this is like a bad divorce already, even though they weren't married. I mean, you could see that things could easily arise, given what happened with the ex parte order and all the, hey, can you meet me at the park? And I go to the park and I wait, you don't come.
Yeah, you wait for 3 hours, and during that time, he's getting his court order to take the baby from you.
Right.
It just, when people saw him, because nobody had really seen him before, he appeared, the things that were said, the opinions that were registered, slime ball might be one of the nicest things that was said about the guy. Too bad. I don't feel sorry for him, but
I feel sorry for the baby, and I feel sorry for
the mom.
And I feel sorry for the mom. No, look, we're not talking about the merits of the case. We're talking about the fact that they went in to try to get something proactively changed so that there wouldn't be a violation of the basically a breathalyzer test, right? The SRAM monitoring. And instead, she ends up in jail because with the worst possible circumstances. So now you end up in. It was just. It's. There's an author called Kafka with the trial. And people say Kafkaesque.
Yes.
Well, you have to Google it. I mean, I know it's not a modern thing, but it's like something out of a movie. It's like Twilight Zone.
Surreal, yeah, no doubt about it. And so, let's look back now at the document that was available actually the day before, but we had that little Alan Jackson thing going on. So
we kind of.
So we didn't look at this at the time.
And while you're doing that, somebody wants to know, wants to know what's in the book club. I thought to say that. Well, it's in our members. It's not.
And it hasn't.
You want to know that you want the title of the book club.
There it is.
Okay, here you go. You might go to prison even though you're innocent. Justin Brooks. So Justin Brooks is going to read a passage.
He is going to read
to our members, right?
He's going to read a passage. I am focusing him. I already told him this on this. This chapter is called, I think it's called "Somebody Lies." This book is really, a collection of the stories, both good and bad, about those that have been wrongfully accused, wrongfully convicted, and ultimately released. And a lot of it has to do with, here's how it could happen to you, whether you think it might happen or not. Here's how it could happen. And this is a chapter called "Somebody Lies About You." Right. I focused on this and the subheading, which is police officers. Know of any cases where police officers have lied and that might be done to help their cases? I don't know.
Well, on Thursday of this week, we'll give you a little preview. Marty Tanklift, who was both an exoneree and then he was wrongfully convicted, exoneree, went to law school, became a lawyer, just admitted to the U.S. Supreme Court, and is also a professor of Georgetown of the Exoneration Project. There, where he and the students have exonerated people wrongfully convicted, and they're going through a bunch of cases where there is police, shall we say, I'll just say it for the moment, faulty testimony. And we actually talk on Thursday, and we will be talking and giving you letters that we've written or memos that we've written. I guess emails would be the correct way to say it. With regard to this case, Teresa Fusco, 41 years in New York City, not solved until recently, 3 innocent people, 2 younger, 1 a little bit older, but who had kids, wrongfully convicted, spent near 18 years in jail. And guess what Marty says? There's no accountability. So we have actually written an email, which we will share, to the prosecutor involved in that case, and also to the law school where he presently teaches, to ask why he's not teaching a case on wrongful conviction. So we'll go into that with Marty Tankliff. It's an amazing interview. He's an amazing guest. It's an amazing story from him, and also an amazing story you'll see that, yes, it can happen to you. You can get wrongfully convicted even though you may be innocent.
Yep. So we will do that. I know it's going to be one day next week. I haven't figured out exactly when, but Justin will be coming on to read some of his prose and give us some tips on, there's got to be a way to avoid this. And obviously,
Yeah.
there's only so much you can do. Sometimes just being in the wrong place at the wrong time, and it doesn't go well. Anyway,
Right in our chat. One of our chatters. I'm not 23, Sherilyn. Okay,
wow.
right in our chat. I mean, I'm sure there's more. People don't want to say it, but it's not a joke. It is not a joke, and it happens. And those of you who don't think it doesn't happen, maybe we'll open your eyes with Justin Brooks's book.
Yep. And Marty, tomorrow will be a great entry into that whole crazy world. So here is the parties' joint memorandum, Ray venue. Now, I will say again, let me blow that up a touch. From last week's extravaganza, you never would have assumed that they would come to terms on venue. You would assume there's apparently a knockdown drag out going on here where Justin Alien has come up with all the things he did to move venue to Middlesex County, Stowe, and everybody else was fighting against that. Well, let's go through this because I think maybe they went out and had a drink somewhere and decided something different. So, basic facts, most importantly, prior to the child's birth, the parties resided together at the mother's residence, Phillips Brooks Road, the now famous residence, in Essex County. The parties and the minor child resided together at this address after the child was born. So they're going through these basic fundamental facts about where they were. We're talking about contacts. If you look at, it's fundamental law school stuff, contacts. That's what this is all about. Venue, jurisdiction. It deals with contacts. And it sounds just as obvious as it is. Where do you work? Where do you go to school? Where do you go to the doctor? Where do you pay your bills? Where, all of those contacts determine where you should be. It makes perfect sense, right? So let's go to last week, number 9 here. On October 23rd, the father testified in court that months later, he changed his voter registration, his car registration, and ensured and certain bills would no longer be mailed to Phillips Brooks Road. Although the father did not testify or explain where his permanent legal address would be, or has been given to the state of the legal actions between the parties, father did represent that he intended to return to North Andover, Essex County, because of his employment, which was the first question I got as the judge was starting her Q&A. I was like, well, you give up the job? No, you didn't. And the child's pediatrician is there.
I kind of, can you stop at that paragraph? Go back.
Yeah.
Go back. I kind of missed that. I thought when she was asking, I changed it right away. Not that it was months, and that I didn't hear about intended. I heard that he'd gotten a special dispensation to be 2 miles out of the 20 miles. Somehow I missed the import or this paragraph 9 when I was listening to us, recording it, you in particular recording it for the streaming networks.
Yeah. So he tried, and that's what was confusing to me when I saw this. Well, he was trying very hard to make this change. Obviously, somebody got him in a headlock. Hey, dude, this is not going to work very well, and here's why. You can't create this. I called it sandbagging, again, on the court house steps, where Julie Hess and Tim Bradle were, more diplomatic than me. And they wouldn't acknowledge that, but it just seemed, to be stacking the deck. And that's basically what this stipulation or joint statement acknowledges. Those changes don't matter. The law says it's where the child was born. So, and these other little points of contact, no matter what you do soon after the fact. 11, father represents that he had no intention of calling Stowe, Mass. And they put an E in here. It's not. Trust me, it's not. Stowe, Mass. His legal residence as of July 1, 2025, when he filed the complaint. But given he was pro se, this is the court saying we're going to give him a little bit of a pass. He listed the temporary address where he was staying, as he has no permanent legal address at this time. Now, that's his parents. He's with his parents right now. So is all of this been concocted to create this additional venue where he, as a pro se litigant, felt it would help him? And that's me giving him a bit of a pass because he didn't know what the hell he was doing. I don't know if it was nefarious, it was negligent, it was stupid. I don't know what the motivation was. Continuing on here, 12, he states in his memorandum filed for that hearing last week, he has long-standing ties to North Andover. He argues, and mother agrees, that North Andover was the child's only true permanent residence since birth. And that's as controlling as they're going to get, right?
Right.
So, as with any good statement, you got your facts, which we just talked about. You got to go to the law. So, under the law, actions under this chapter to establish parentage, support, custody, visitation of a child shall be filed in the judicial district or county in which the child and one of the parents lives. And if neither of the parents lives in the same judicial district or county as the child, then the complaint shall be filed in the judicial district or county where the child lives.
That's pretty. I mean, it kind of says it right there. It's where the child lives, and the child only lived in North Andover.
Yeah. So,
unless you want to take the child, you move the child to a different county. And the child now lives here.
And then you file. Yeah. We live in my car, so wherever we're parked. Well, the court actually looks at transitory matters like that. Even for transitory actions, in this 209C action could be construed transitory. I guess that's not a bad argument. Venue is generally proper in the county where one of the parties resides or has their usual place of business. So again, we're back to his connections to the firefighter. The question does not turn on whether either party or child moved after the filing, nor where one's temporary address happened to be at the time of the filing. The question of residency of the child hinges on where the child resided prior to the filing, which by all accounts was in Essex County. Okay, so that's the story.
Clear. That's pretty clear what the law is, and that's why it had to be in Essex. But no one wanted to say that, so I guess there was there's some negotiations that were going on, and whatever it was, but the negotiations do give custody to the dad now.
Yeah, and I think, imagine being in that room, and you're negotiating, right?
Right.
And you're negotiating on behalf of the father. Well, you got a pretty good leverage. Hey, mom's in jail.
Mom's in jail. Right.
Mom's in jail. So here I am, the only free parent. So that's huge.
Right.
And I'm sure they leaned on that heavily when they were putting this together to get some of the consolations that they did. And I'm also sure that Julie Hess and Tim Bradle said, this is temporary. We know what we're fighting for, which is to get Kelsey Fitzsimmons out of jail.
Right.
That happens. We come in with our new paperwork that says, emblazoned on it, changed circumstances, right?
Right.